Good afternoon, and thank you for attending this presentation on education laws for new teachers. Our agenda today will be law and policy information, the legality in new teacher positions. We will learn more about how our laws govern our schools in the United States. We will hear some legal cases and current regulations that teachers and students must adhere by. We will go over takeaways. I will give you a little bit of some more information on what is next for you as a new teacher. And obviously, I will share my references and information cited. Here's some information for new teachers that I'd like you to think of. Are you able to search and seize a student's belongings with or without probable cause? How much is too much to share when speaking with a school leader or boss? Have you ever wondered if you can withhold services to a student who might have an IEP or 504 plan in place? What is allowed to be done for those students on the IEP or 504? Are you able to openly write and vocalize your stance, whether that's in public, in private? How far does your disagreement or opinion go when making decisions? And what are current state and federal laws that protect teachers and students' rights? I feel that new teachers should be aware because new teachers are in a very tough position. You're getting your career on track, your life together, and you're starting all of this, and it can be very overwhelming. So it's very important that new teachers are made aware of certain situations that can affect you. Teachers should know building policies, state guidelines, and district policies. Teachers should be up to date with new changing policies at the local and state levels. Teaching styles and classroom rules can all be different and change between teachers, but if you have basic guidelines that are consistent with one another and what your building expects, then you should be good to go. Not only does this help you with peace of mind, but it unifies your school and it makes parents, teachers, and students aware and all on the same page. Teachers should utilize their new mentor 100% and/or any coach or veteran teacher for guidance and information about these laws. Just to dive in a little bit to the laws in our school system, we can look at all of the entities that control education and their laws. There's the federal level with the U.S. Constitution's 10th Amendment, which gives each state the right to govern public educators. Federal government does not control public education, but it does have the right to hold states accountable. Each state is tasked with the responsibility of creating and enforcing laws, and locally elected school board officials have the most direct control over school functioning and funding and school decisions. They write and legally enforce policies that reflect the values and needs of their community, which those are gathered by parents and teachers who attend school board meetings. So as you can see, there is a whole triangular systematic approach to make sure that schools are run effectively and efficiently. Now that we have set the foundation for what we're going to discuss today, I'm going to give you 6 areas of regulation and discuss some landmark cases that stood out to me that I wanted to share with you and how these current laws affect us. The first one focuses on student rights, and this was from the 1969 Tinker versus Des Moines case. Mary Beth Tinker was a junior high student, and she was suspended for wearing anti-war paraphernalia, clothing, and accessories. This was during the time of the Vietnam War. As the First Amendment says and protects students, they are granted the right to free speech, but it says do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. How it affects us today is the court found out that the First Amendment applied this to public schools, and school officials are not allowed to censor speech unless it is disrupting the learning environment and educational process within the classroom. Another situation we'd like to look at focuses on teacher rights. This is Givhan versus Western Line Consolidated School District, which happened in the year of 1979. An African-American public school teacher in Mississippi believed that the school that had more black students enrolled was not receiving an adequate school supply list or school supplies compared to the school with more white students attending. After much look and deliberation, the federal court district ruled in favor of her on her claim, but the Fifth of the Court of Appeals reversed it. This determined that she had no First Amendment protections because she had communicated her views privately rather than publicly. So this kind of shows us that some things are much more important to talk about and discuss to get things changed. How I felt that it was implemented today was that some cases receive First Amendment protection for expression made at work, and it's ruled that public employees do not retain the First Amendment protection for purely job-related expression. As we look at teacher rights, we can look at the scenario. So if there is a teacher at your school and he's made friends with many staff members and invited them to visit his social network page, on this page he's listed a lot of information, and some of you have friended him. One statement that you read on his profile suggested that this teacher was attracted to younger girls, and there was a quote directly stating, "The younger the better." The colleague of yours or yourself noticed this and informed the principal. So you just have to think, what will happen if I speak up? If the colleague or yourself notifies the principal of this information, what's the next step? In this situation, the school board decided to put him on paid leave pending an investigation into the matter. This is where I want you to take some time and think, is this legal? The correct answer is no. However, it is your school's situational decision to decide what will be done due to this. The next thing I'd like to talk about is school safety. In this case of New Jersey versus TLO, a student was suspected of possessing cigarettes and was searched and ultimately charged for possession of marijuana paraphernalia. It became a Supreme Court case, and the Fourth Amendment, which provides individuals with protection against unreasonable search and seizures, was interpreted in relation to its implementation of a school setting. So basically, the Fourth Amendment stipulates that police officers must have probable cause and a search warrant in order to search someone's belongings. In this case, the court decided that in a school setting, though, school officials may search student belongings without consent or a search warrant. The ruling is important for schools because it really does allow us to maintain safe environments for not only our students, but ourselves. So schools only have to meet the standard of reasonable suspicion to engage in an activity related to the Fourth Amendment. Dealing with a school safety scenario, there might be more times than not that we get thrown into these situations. So I'd like you to just take a second and think about this one. If you've been observing a student who's frequently asking to use the restroom during your class, the student comes back, they're disheveled, their eyes are bloodshot, they seem off, their balance is a little irritated, and they smell of alcohol. Some of your other students have created chatter about this topic, and the behavior of your students is being greatly affected. So if the incident continues, the administration is now made aware and decides to step in and search through the student belongings and anything related to this situation. I would like you to think, based on what we've learned about school safety scenarios, if you feel this is legal. The next domain we're going to touch on is students with disabilities. This next case is the Board of Education versus Rowley. The case dealt with a hearing impaired girl named Amy, and school administrators were also part of this case, along with a sign language expert. It was determined that Amy did have hearing impairments, but she was able to succeed in school without an interpreter. Amy's parents sued the school on her behalf for the violation and neglect pertaining to the Education of All Handicapped Children Act in 1975 that was established. So this act requires all schools that accept federal funds to provide free and appropriate public education to all their handicapped enrolled students. This act also allows schools to decide what steps to take to accommodate those handicapped students. However, the act does not require a school to provide sign language interpreters to a deaf student when otherwise receiving personalized instruction. School administrators are allowed to determine what this child needs and what is required to meet the learning needs of this individual and see success in their education. A scenario to think about is a kindergarten student is having trouble seeing the board, and you've noticed that motor skills are off, connections are not being made. So a conference is held and it's established that the student is visually impaired. More than most, the student is considered to be more than 75% blind. This student is now required to learn the ins and outs of navigating the school with a walker. She has minimal OT support, and a lot of the accommodations need to be established and brought into the classroom by the classroom teacher. The parents and building leaders have decided that they would like to receive more accommodations for their daughter. These might include larger text, larger prints, assistance through the day, learning Braille, possibly even an aid. There is a newly implemented IEP for the student. However, when brought to the attention, the district decided who is in charge of the funding for these situations, the access was denied. It was stated that the equipment and additional support will not be provided by school funding. I would like you to think again to yourself and talk amongst yourselves, is this legal? Discrimination in 1954 deals with Brown versus the Board of Education. This was a very popular case, and it made a lot of headline. The Brown versus Board of Education was a landmark decision in 1954 that actually overturned the Plessy versus Ferguson case in 1896. So it really went on with the whole quote, separate but equal. The Supreme Court ruled that the segregation of students by race led to unequal education and was a violation to the 14th Amendment. I feel that this law is important for schools because children, regardless of race, among other differentiating factors, are legally entitled to receive a public education, and they have to have equal treatment. Our school board policies reflect this foundation of anti-discrimination laws and the support of equal education for all students. Schools adhere by the 14th Amendment and Equal Protection Clause and other anti-discriminatory laws. Dealing with student conduct and discipline in schools, this case was motivated by the discovery of student athletes, and it's proven that student athletes are more prone to being in a drug culture, meaning they can raise concern with drug increase. And this could be because they have sport-related injuries, they could take drug enhancements. So the school districts adopted a student-athlete drug policy. The policy is constitutional under the 4th and 14th Amendment. Schools today, implement it by drug testing and having a policy in a lot of high school students. And this is governed by each district differently. But looking into specific school policies, that will finalize and give the guidelines for drug testing. Every school, though, requires a policy that if you participate in sports, it requires the student's consent in order to participate and be drug tested. As for the newest cases, this deals with a case in the state of Maine, Carson versus Macon, and it relies on local school administration to ensure that every school-age child in the state is receiving and has access to free education. However, that is not always the case, and public schools are not always accessible. To meet the requirements, though, an SAU without its own public secondary school may do a couple things. One, they can contract with a secondary school to provide school option and privileges for students to learn. Or the second option is pay a tuition for a secondary school where the student has been accepted. Either way, this school must provide public education or an approved private education. So a situation might be a voucher system or something of that sort in terms of tuition. To become an approved secondary school, the location and representatives for that school must meet the state's compulsory attendance and requirement standards. After we have talked about everything, we've covered a lot of ground discussing 6 educational laws and some landmark Supreme Court cases, some federal laws, and some state laws. The legal system does surround education in a very complex way. So I would like you to just sit and think about some takeaways and the constitutional rights that we have in education. This chart outlines some of the examples that we discussed today, and it connects them in a pretty easy way for us to understand which amendment goes with which right. So if you just want to take a look, you can see the backbone of education law and our school's policy, honestly, is the U.S. Constitution. So you might be thinking, okay, what are my next steps and how can I apply any of this information to being a new teacher? So for sure, I would like you to look further into your state, their code of professional conduct. You can find all of this information at the Ohio Department of Education website. If you need help navigating, I would love to do that for you. You can ask questions and get all information needed from our HR representatives, school administrators, new teacher mentors, or anyone who is in a veteran position. Attending professional development will do so many things for you in the classroom, but it will also help you so much outside of the classroom. If you feel that you, a staff member or a student, is suffering from rights that are being violated, it is very important to speak up and immediately tell your building principal or administrative team. The 3 final slides are references that I use for this presentation. I appreciate your patience during this. If you have any questions afterwards, I would love to table them. And I hope you enjoyed learning about the educational laws for new teachers.